Hello and welcome. In this lesson, we're diving into a crucial aspect of legal practice: legal negotiations. Legal negotiations are an art, a delicate dance where each move can have significant consequences. Today, we'll explore the key principles that form the foundation of successful legal negotiations. The first principle is preparation. In legal negotiations, knowledge is power. Before entering any negotiation, thoroughly research the case, understand your client's goals, and anticipate the opposing party's arguments. The second principle is active listening. Effective communication is at the heart of negotiations. Listen actively to not only what is said but also what is left unsaid. Pay attention to nuances, as they often reveal hidden interests. Now, let's focus on the key expressions used in legal negotiations. These phrases carry a nuanced meaning, and can significantly impact the outcome of a negotiation. A critical expression is good faith. Negotiating in good faith is a fundamental legal principle. It implies honesty, fairness, and a sincere effort to reach a mutually beneficial agreement. Courts often expect parties to negotiate in good faith, and a lack thereof can have legal consequences. Without admission of liability is a phrase frequently used in settlements. It allows parties to resolve disputes without acknowledging fault. This can be crucial in protecting reputations and minimizing the impact on future litigation. Subject to contract. For example, in a discussion we can say, while we're discussing these terms, it's important to note that everything is subject to contract until a formal agreement is reached. Confidentiality agreement. Sometimes we can say, before we proceed, we may need to sign a confidentiality agreement to ensure that sensitive information shared during these negotiations remains confidential. And if the other party make an offer, but you want to make another one or counter offer, you can say, "We appreciate your proposal, but we'd like to present a counter offer that addresses our concerns and aligns better with our client's interests." And to show flexibility and willingness to compromise, you can say, "In the spirit of finding a mutually agreeable solution, we are willing to make certain concessions to move the negotiation forward." If you are discussing sensitive information during negotiations, you need to clarify that by saying, for example, "Before we proceed, we'd like to discuss the possibility of a confidentiality agreement to ensure that any information shared in this negotiation remains confidential." Let's consider a situation where you need to add changes to the existing agreement. You can say that, "In light of recent developments, we propose certain amendments to the agreement that we believe will better reflect the current circumstances and ensure a more equitable outcome." And if you want to indicating that the presented offer is the last and most favorable, you may say, "In an effort to bring closure to these negotiations, we are presenting our best and final offer. We believe this is a fair and equitable resolution." When correcting factual inaccuracies in the opposing party's argument, you can say, for example, "I'd like to clarify a factual point. Contrary to what was stated, our client did not receive the goods on the specified date but rather after 2 weeks. And when seeking clarification on any legal points, you can say, "Before we proceed, could you provide further clarification on specific legal point?" This would help us better understand your position and facilitate a more productive discussion. When contesting the opposing party's interpretation of the law, maybe you can say, respectfully, we disagree with your interpretation of this legal provision. Our analysis aligns more closely with the legislative intent, as outlined in law. Well, so in case you want to emphasizing specific terms and conditions in a contract, you can say that let's revisit the contractual language in Article X, which explicitly states that our argument is firmly rooted in the clear and unambiguous language of the agreement. Now let's take a look on this example in negotiation meeting, while one party try to convince the other party with his perspective, and see how is it going.